Ponton back for another VA Q&A. We're excited to have all you guys here to be, as always, learning from y'all, and hopefully we can dispense some wisdom and information we've learned along the way to help y'all. So today, what we're going to talk about, Carol and I have been talking about, and frankly, if you've seen our newsletter this week, is C&P exams. We get so many questions on those, and just there's so much of the VA does wrong, and there's so many traps there. So just a little later on, we're going to jump into that. But first, we'll just start in with questions, and then once more folks get here, we'll hit that. So let's start with the first question. Okay, from Mike H. Outside of Qs, what are the ways to get an earlier effective date? Thanks. Well, Carol, what do you say to that?
Well, Q is clear and unmistakable error. There's also open claims, which I think you may have bunched together, but they are different. An open claim is one where somebody filed a claim and it was never acted upon. Or you appealed a claim and the appeal was never acted upon. So those are other ways, but basically at Qs, those two things are the only way to get an earlier effective date because they're coming under one of those names. Now, an earlier effective date can be from the Nehmer cases set up a lot of opportunities to get earlier effective dates. Because
what's Nehmer?
Nehmer is the court case that handled the Agent Orange exposure in Vietnam. And the court initially said that diabetes was related, and then over the years, additional disabilities have been added. And what's important about that is, say you have a veteran who had a claim for hearing loss, and at the same time he had a heart condition, and this was in 2010. Well, later on, the VA had added heart condition cardiac to that. So the veteran may be able to go back, and because the VA says under Nehmer under only just these Vietnam cases, if you have any claim pending and the medical records in the file at that time show that you have what is a presumptive claim, then that is a claim for that as well. So that's another way to go back. There's just a lot of, I don't have a list. It's a thing
there's a lot of exceptions. One of the biggest ones we used to use was the regulation 38 CFR 3.16B, 38 CFR 3.16B, 1.56B, sorry, 1.56B. And basically what that said is that if a veteran submitted any evidence within a year of a decision that was relevant to that decision and the VA did not issue a new decision, then that claim was still open. Going back to what Carol said is about, was it a claim appealed and not resolved, or was there a claim in there that was not adjudicated? In any of those things, you're going to have to get in the C file. You're going to have to order your C file. You're going to have to do a chronology of what was submitted when, and what did the VA know, and when did they know it. And that's what we do. We have a special software that kind of goes through and lets us input every single document in there, and then we can look and see when did the VA have knowledge of whatever they were adjudicating. So you can get earlier effective dates. There are quite a few exceptions, but they are exceptions, they're not rules. The one I just discussed, 38 CFR 3.156B, is no longer in effect with AMA, but it is in effect for any claim filed before AMA, which was
right. So before 2015, right?
2019.
Huh?
AMA was 2019. So anyway, that's what those are ones to look for. They're not easy, but to get them, you're almost definitely going to need to get your C file.
And one other response I'd say, it not only remember the medical records have to be in the C file so that the VA would have been aware of them. An exception to that is the VA medical records. The VA medical records within the next year may show that the veteran went back into a mental institution regarding his mental claim. That reopens the claim. There are just so many little things, but that's the problem with VA law. There's no list. It's 30 years of doing this work that you see these exceptions and see them in the cases. So
and they come and go.
And they come and they go. As soon as we get them, the VA tries to take them away, like they did the section Matt was just talking about.
Yeah.
But that's what gets me up in the morning. It's like a treasure hunt, trying to find the earliest effective date I can for veterans.
Glenn, 23 years Air Force as AC refueler. diagnosed with migraine, sleep apnea, and neuropathy, having hard time service connecting. Do I file for jet fuel exposure syndrome? Currently 60% for tinnitus, vertigo, insomnia. Do I include those in my claim? Okay, let's answer that last part first. To include the ones you're service connected for in your claim, you'd basically be saying you have, you need a higher rating for those. So you need to determine, are the ratings proper? Jet fuel exposure, you were as exposed as anybody. I would definitely put that in there in a letter saying this is what I did every day, day in, day out. They should get a CNP exam. I doubt the CNP exam is going to be favorable and that it's not going to look at everything. So you're probably going to be looking at getting an outside exam. You need to get the CNP exam first just to see what they say, but I think an outside exam is where you're going to have to go. But I think there's merit to your claim.
Yeah, I think you should Google the medical treatises that show the connection between these things, submit that with your claim, and then the VA is true to form. They're going to ignore all that. They're going to have some examiner who just says, it's my opinion that this isn't true or not connected. They're not going to cite any medical treatises because there aren't any. So
Right.
You've gotten that in, but you're going to need a nexus statement, I'm certain. That's one of the things that we know we're going to have to send to our doctors.
Okay, Janetta, I've been fighting for my ANA benefits for the longest and continuously getting denied because I was not scheduler 100%, only IU. They're saying I'm not entitled. How can I win? Carol?
Hopefully you'll get a VA person who knows what the law is. Unfortunately, the regional office keeps saying that you have to have 100% scheduler rating. That's not true. If you have 100% under unemployability, that's the same thing, and the courts have said that over and over. You're going to have to go to the BVA most of the times to win. I've tried filing a higher level review, pointing out the case law. Every once in a while that'll win, but most of the time they don't follow case law. They follow whatever their advisor tells them to. So yeah. I think you're going to have to go to the BVA.
But it's a claim you should win.
Yeah, absolutely.
If you need the ANA. PDE 442, as a result of trauma during service, was just informed that my spleen, gallbladder, and portion of my liver must be removed. Should these be filed separately? What other things should be considered? So you file them all at the same time. Those are 3 different claims. Whatever things should be considered, I would speak to your doctor. What will loss of those issues cause in your body? Are there secondary problems? Is there fatigue? Is there, is your blood functioning off? Does it affect your kidney? I don't know, Carol. What else? Is there anything
else? Service connection for spleen, secondary to trauma and service. Service connection for gallbladder, secondary to. So you need to make sure you're showing exactly why. The other trauma, I'm not sure, was there, as Matt says, was there trauma to something else? Did you have hit your brain, hit your head? I would file all of these, but make sure they're related to trauma so the VA knows exactly what you're filing for.
And then talk to your doctor about, doc, what's going to happen when I lose these 3 organs? Is there side effects? And then that's what you'd want to file for, those side effects or secondary issues.
And as always, if there's depression, anxiety because of this trauma, make sure you're filing for that as well.
Dave, hi. Worked in naval nuclear role directly with nuclear contamination. Got cancer 30 years later. Everything I read says they never approved tonsil cancer. Non-smoker. Is it worth even trying? This is a hard case because you have to show how much nuclear radiation you were exposed to. And then once you do that, it goes to the Mississippi regional office and they determine if you had enough exposure to cause some kind of cancer. That is not something that can be overruled. There's no expert that can come in and say, no, what the VA said was wrong here. That being said, it's definitely worth trying. I mean, if there's no other etiology possibilities here, I mean, you didn't smoke. If you don't have any familial history either, I'd try
testing to show that you genetically were not predisposed. But this is a hard case. The VA has really controlled these. It's amazing that everybody seems to have the same low rate of exposure.
Yeah.
And it's a hard case. I would try looking at any role you had as far as maybe cleaning. Did you work with tools that had fluids that cleaned? Or I would try to see if there's something else you did that would expose you to things that are known cancer causes.
Kenneth Dennis, can you use GI Bill while on TDIU?
GI Bill for
Yes.
what?
Oh,
I guess going to school?
that's what I was thinking. Yeah.
I would think you can.
Yeah, I
You could
don't see
also
any
use
reason.
the vocational rehabilitation.
Oh, right. Yeah.
So,
Robert, VA psychologist, diagnosis of PTSD due to a documented repelling accident. Can the C&P examiner dispute the accident as the stressor when it is documented in medical records that it is the stressor? Yeah, they can, should they know, but they can just because they feel like they can do anything they want. So if they do that and you have a doctor who's willing to go back for you, I would go back to your doctor and say, why does he think that this caused your PTSD? And if you would, comment on what the C&P doctor says. The other thing I'd consider doing is you writing a letter talking about what the C&P experience was. How thorough was the doctor? How many questions did he ask? What records did he tell you he was looking at? How long did the exam take? And then you can compare that and say, that's what this guy did. And then meanwhile, I've been treating with my doctor for what, 6 months, a year, 5 years, and he knows me really well, and we've discussed these things thoroughly, things that the C&P doctor didn't even bother asking me. That's infuriating, because the C&P doctor, all they need to do is confirm the diagnosis. I believe in that standpoint, but a lot of times they go this step further that just makes it longer for you. So,
and I'd also allege duty to assist violation.
oh yeah,
The VA cannot rely on opinion that's inaccurate. And therefore, I would say there's a duty to assist because they relied on an opinion from someone who had inaccurate information as a basis of their opinion, because it is confirmed in the medical records that this accident occurred.
yeah, especially if the VA itself conceded the stressor, meaning the adjudicator is the one that said, okay, this is a stressor. Is this PTSD related stressor? Is the question to the C&P examiner. But C&P examiner sounds like they went back and said, no, there's no stressor here. So David Anderson, I was granted 100% disability for my malignant skin cancer carcinomas resulting from herbicide exposure. Reason for decision is 38 CFR 4.118 DC 7818 that states, in part, 100% evaluation will be assigned from the date of the onset of treatment. How do you interpret this? In my case, the onset of treatment was 1972. I interpreted that, oh, go ahead, Carol.
You have to file a claim unless it's NEMR.
Yeah. So it's either the date of the claim or the date of the diagnosis, whichever is later. Okay.
Right.
So if unfortunately we're talking over 50 years, that you don't go back until the date of the claim.
But if this is under NEMR, for instance, if this were under NEMR and this had been going on and whatever the particular cancer you have is presumptive, then you could, that would be when you try to reopen.
S. Tom, thank you for the awesome education assistance you provided in these videos on your website. I hope you two won a ton in Vegas. Cheers from Germany.
We could have gone to Germany for what we spent in Vegas. Right? Let's try that next time.
I don't want to talk about it. But yeah, I still had to buy that darn ticket for Alabama, and they're still in it. So
yeah, I bought one. He bought one.
We'll see. We'll see where that gets us.
Better be right.
Eli, 20% for hearing loss and tinnitus, pending claim for depression. How hard is it to claim migraine secondary to tinnitus? How do I get a diagnosis? Well, you got to have a doctor, preferably a treating doctor, tell you that you have a diagnosis of some kind of headaches, migraines, cluster headaches, something like that. If you don't have that, the claim's dead in the water before you even file. You could file and hope that the C&P doctor would give you a diagnosis. That's worth trying.
Yeah, but most of the time, the C&P doctors, if there's not a medical record showing you have a diagnosis of headaches, they're just going to say there are no headaches. They're not going to diagnose you. So you get that. And, it's funny, the VA, how do you get headaches secondary to PTSD? Well, the VA has talked to their examiners and explained to them how you can't possibly get that no matter what the medical records show. So you're probably going to be denied on that. Tinnitus is one they haven't gotten to yet. So I find that I've been able to get veterans migraines, sleep apnea, a number of things secondary to tinnitus that isn't on the VA's radar right now. So if you have these things, I would definitely try to get them service connected secondary to tinnitus.
Agreed. Anthony, good afternoon. Please explain favorable findings and the tie goes to the veteran concerning medical evidence. Part 2. What is the issue? Part 2. What is the issue with the often misdiagnosis of adjustment disorder by military doctors? Okay, so let's go back to part 1. Favorable findings. One of the I will say few bright spots of this new era we're in, this AMA era, is that
very few.
In the rating decision you receive, the VA has to state what parts of the claim you're claiming they believe they believe. Well, that's probably a bad way to
They
say
will
it.
accept.
They'll accept, yeah.
As a finding.
So let's take PTSD. Okay, you're trying to service connect it. You got to show you have a diagnosis of PTSD, something happened in service, and you have a nexus. Okay, so let's say they come back and say you have a diagnosis of PTSD, and we concede a stressor of you being an automobile accident service. However, there's no nexus. The C&P doctor said, it's related to something else after service. Okay, so what that does for you in favorable findings is it narrows the claim. No longer do you need to worry about going to your doctor and saying, hey, make sure I get a good diagnosis of PTSD, or hey, VA, was this stressor a conceded stressor? You've got those, okay? Now what you need to focus on is the one piece of evidence you don't have, the non-favorable finding, which would be the nexus here. Those favorable findings follow you all through your claim. So you can't have an adjudicator higher up in the line say, oh, he was wrong. That wasn't a conceded stressor. We're taking that back. So that's a very powerful piece of evidence, and it helps you shape whatever you're going to do next in an appeal, a supplemental claim, go to the board, whatever. I don't see Ty going to the veteran.
Yeah, that the benefit of the doubt, that is the biggest deception ever. Congress gave it to the veterans and the VA never applies it. Unless you've got 5 favorable things against one negative thing, maybe they'll give you the benefit of the doubt. But
that's what's infuriating is when you have overwhelming. That's what I hate. It's you have overwhelming evidence and they're saying, okay, we'll give you benefit of the doubt. And it's like, no, this is not where this applies. Anyway, as far as the misdiagnosis of adjustment disorder, my understanding of adjustment disorder is that it is a short-term disorder that lasts 3 to 6 months. Right. We see all the time where the veterans denied service connection for an adjustment disorder. That's what they're still diagnosed with at the VA. And yet they've been battling that mental condition for anywhere from a year to 3 years to 5 years. So I think the military doctors put that in there so they don't have to put PTSD. That's kind of how I see it. But yeah, I don't know, Carol.
And so when you appeal, you want to say, I did not claim for that. That's not what I have. I have depression, anxiety, whatever it is. Here are the symptoms.
Yeah. All right, Nate. Let's break out that one. Great.
This is it.
This is the question. Yeah, we had a question that was submitted via email. They asked us to make sure we talked about it. Last year, my retired combat decorated Marine Corps brother completed an intent to file for PTSD. 2 weeks later, he took his own life before he submitted a claim. His DD-214 has combat action ribbon, Gulf War, etc. Since he did complete the intent to file before the death, can his wife sub for him and complete and submit the claim? So what his wife needs to do here is file for DIC. Okay, that's a type of monthly pension that a spouse or survivor can get if the veteran's death was due primarily or there was a contributory cause that was service connected. Now, the fact that he was never service connected for PTSD doesn't matter. She would have to show that the PTSD was related to service. So in a way, she's proving service connection. And then once she shows that, she's got to say this either caused the suicide or was one of the proximate reasons for the suicide.
So there are a couple of questions in here. One, the first thing we looked at is he filed an intent to file. Does that mean that now we can go and file a bunch of claims? The problem, okay, so when someone dies, the survivor, the widow or the widower, is entitled to continue a claim that was already pending and to file for DIC benefits. So right now, the first thing we would say is the most important thing would be the DIC benefits. It's not based on income, it's based on service connection. And it doesn't matter if he never filed for PTSD before. When you file for DIC, you can allege anything that you think was the cause that shows service connection. So the second thing left, intent to file a claim, it really is not going to benefit her because any claims that he filed die the date of his death. So they'd be going backwards. So there's really nothing in the way of a benefit at that short a time period.
Yeah. Okay. And now we kind of like to segue into some C&P exam thoughts we had. Okay. We get a lot of questions, and from here on out, we're going to prioritize any C&P questions just to kind of go over more of these issues. But essentially, you know, Carol and I have, it's hard to even organize our thoughts on all the different things we think about when it comes to going to an exam. The first thing I will say is that you have to go. Okay. If they schedule you for an exam, and Carol's going to talk about why you don't have to go on some reasons, but if they schedule you for an exam, you have to go, or you at least have to tell them why you can't go, or tell them why you'd want to move it. If you don't go and you don't talk to them at all, say why you didn't go, that's an automatic denial they get. Doesn't matter what else you have in the file. Doesn't matter if you had a doctor that has seen you forever and crafted a great opinion. They say, no, we had questions about this opinion and the guy didn't show up to C&P, flat out denied. The other thing I would say is that when you go, make sure you take somebody with you, your spouse, a good friend, somebody. And when you get there, they're going to almost always say, no, I just want to see the veteran. And you need to put your foot down and say, I need this person in here. They help me with my memory. They see things about me that I don't see. I need them in there to help me and make sure that everything about my history is told. Okay. That hopefully will get the person in there. The last thing I'd say before I hand it over to Carol is just when you're at the exam, you know, you need to be an advocate for yourself. You need to say, they're going to ask you the questions they ask you, but if they don't ask the questions that are pertinent to you as far as how, you know, the pain you're in, if you're socially isolating, if you have migraines, how often you have them, you know, you need to say, hey, doc, we didn't talk about these things. I would like you to consider these, and you put that out there. Okay. Then if you feel like you got a negative exam, I would pull a copy of the exam and I would write out a statement saying, this is what I talked about with the doctor. This is how many minutes I was in with him. These are the questions he did not ask. And oh, by the way, in his report, he said X. He never discussed X with me. Okay, so you want to be very thorough in how you present yourself, having somebody there with you, and then also how you respond to it. And here comes Carol. It's going to be a tsunami.
I got a lot to say about these exams. The first thing is, yes, you have to go. And they don't want you to bring anybody in with them. They don't want any witnesses as to what did or didn't occur. But I find that my clients who say, if he doesn't go in or she doesn't go in, I'm not going in. So you take us both or you don't take either one of us. And that person wants to make money, they're going to take you in. But you have to be very firm about that. The second thing I would say is they are awful about trying to get you to run all over the state or the next state. Okay, remember, it used to be that the VA itself evaluate you. That is no longer the case. Now there are 3 companies, Optimum, which was LHI, my favorite, QTC, and VES. Okay, so this is money for these people. Once they're assigned your case, they want to do the exams. So if their nearest doctor is 200 miles away, that's where they're going to send you. You have a right to have this near where you live. Now, they are going to tell you you don't. They're going to tell you it delays. They're going to tell you they're going to deny you. If they do that, you need to immediately, because you can't rely on them. They will say, veteran refused to go. You need to call the 1-800 number, 1-800-827-1000. That's the VA hotline, and you ask to speak to the VA C&P scheduling people. You tell them, I have been called by Optum, because 95% of the time, that's the people that are trying to jerk my clients around. And you say, I am disabled. That's why I'm filing for this. They want me to go 50 miles away. I'm not going to do that. I've also had this company set people up. They drive 100 miles and get there, and the exam has been canceled. Okay. Immediately call the VA number and say, this company has done this to me too many times. I am not going to go through them. Please assign me to QTC or VES or whichever one did not do this to you. This is a real problem. We can't talk to these people because these are scheduled by the VA Health Department, not the VA benefits. And they take the position that there's a Privacy Act and they'll only talk to the veteran. So I need to empower you. I try to empower my clients to know what your rights are. Okay. So that's before you even get there. Once you get there, I want you to remember, especially for people who have mental claims, People who have mental claims may not bathe for 3 days. They may hang around in their pajamas. They may not shave. And then when they have a CNP exam, they dress up and put on a suit. This is not, you want them to see what this mental condition has done to you and your family. You want to go to them as you spend your day. You also want to treat them the way that you treated your family, your friends, people when you wished you hadn't, and show them what this has done to you. Going in and being, hi, how are you? I'm fine. That doesn't let them see what has gone on in your life. And you are going to be denied and you're going to be lowballed. The second thing is if you have suicidal thoughts, that's a 70% rating right there. And most of my clients don't want to talk about it because they don't want to be locked up. Well, you're not going to be locked up. If you go and you have these thoughts, but you're not presently going to do it, then that's not a Baker Act. That's not a reason to lock you up. But by not talking to them about it, by not saying, I get up and I wonder, is life worth living? Am I going to live through this day? You're not showing them what this has done to you. Please let them know what's going on. Now, before our clients go to exams, we try to send them a copy of the DBQ, that's called a Disability Benefits Questionnaire, that this examiner will complete. So when you go to a VA exam, what you're going to be asked has already been laid out before these people. It's the form that we send you. And we ask that you review that form and try to figure out what your answer should be and what's very important. If there's any way you can look at the rating decision, you should do that as well, because I would refer you to the DBQ for headaches or migraines. That is so misleading. There are probably 50 questions on there. And I know often my clients have said, this examiner really wanted to help me. They did a great job, and then he's going to get a 10% from what the examiner put down, because there are only 3 questions that are important on that. Do you have migraines and headaches at least once a month? Do they cause you to prostrate, which means lie down, get in a recliner? And do they interfere with your ability to work? Those are the 3 main questions. The rest of the form really has nothing to do with your rating. So you need to look at the rating schedule to see what they're talking about. Prostrating, I don't know how many people really understand exactly what they're asking there. Does that mean getting a recliner? I didn't know that. And then I want to talk about the evaluations where you have to move. Back, knees. You really need to get those forms because, for instance, your knees can give you a rating for arthritis, that's 10%. They can give you a rating for a limited range of motion. They can give you a rating for instability. Do you have a brace? Does your knee go out of socket? They can give you a rating for a knee replacement. There are lots of things you can get rating for, but you need to know what are they looking for. Same with your back. Your back, the highest rating you're probably going to get for your back is 40%, and that's based almost totally on how far you can bend over standing up toward your toes. The less you can bend, the higher rating you're going to get. But there are also ratings, the way that you get additional ratings for what the back problem causes you is radiculopathy. Do you have pain and numbness going down either leg? Do you have a voiding problem? Do you have to go to the bathroom a lot because the disc is pressing on your nerve and causing you to do that? So get the DBQs out and read them. They're really, really important, and get a rating decision. It's online. You can get the rating decisions that say exactly how they're going to rate this. I could go on forever, but my final thing, Matt, is with the PTSD, I really hate those exams because the VA has decided in their infinite wisdom that you cannot have PTSD unless you meet the criteria that they have set out on their form. So you get the DBQ for PTSD and you go to page 4 and it says criteria. If you don't have something for each one of those, you don't have PTSD. And the thing is, VA has amnesia. The fact that you had PTSD for the last 10 years has nothing to do with this exam. Every time you have to meet that criteria, okay? So get the form out, make sure you know it, make sure you comment on all the things that are important to you. Final thing, okay, Matt, I could go on all day, as Matt knows, is unemployability. Unemployability is when a service-connected problem keeps you from working, okay? So if you have a rating for your back and it keeps you from working and you're not working, the VA should evaluate you for unemployability due just to your back. They're not going to do that unless you ask them. You have to file the form. But when you get in there to talk about unemployability, remember the only things that count are what is service connected. So if you have a non-service connected problem and the person wants to talk about it, the examiner said, that's not why I can't work. These are the problems that keep me from working. So you need to know, what is this exam about? What does the law require? And make sure you keep the examiner and yourself on that track. Don't let them get you off of it.
Carol, I would add to that.
And that's my synopsis.
I would add to that on the unemployability. You can have more than one reason that make you unemployable. Okay, so let's say you are, you went on Social Security disability because of your back due to an injury at work. Yet at the same time, you have uncontrollable rage due to your PTSD, which is service connected. The VA cannot consider your back because it's not service connected, therefore it's not relevant. They have to look at just the PTSD and say, could this alone keep him out of the workforce? Okay, that's another big thing they do, is they say, well, we already know you're not working because of the PTSD, or excuse me, because of the back. So don't let them do that to you either. All right, so let's see if we have any questions on CNP exams, since we're trying to focus on that. Sergeant Wilkie, hi all. What's the current wait time to receive an answer after a CNP exam? I mean, the VA is saying a couple of weeks, but it depends. Sometimes the rater will say this exam's not good enough and they'll send it back. Sometimes, it'll take the CNP examiner too long to send it to the rater, but I would say 3-4 weeks, and you want to check, and hopefully you can get a copy of that before they make a decision so that you can point out any errors that were there before they decide the case on for you. Donald, what is your take on DBQs from a PA or nurse practitioner? Carol?
Well, first, if they're not good, then I want to point out that so many of them are family practitioners. So when you have an orthopedic problem, or when you have a diabetic problem, then that's not their specialty, and a neurological. So I always want to point out, if you have a doctor who's a neurologist, that's the person they should be listening to, not someone that doesn't have that type of degree. I can tell you that the BVA doesn't love that. There are a lot of judges there that want a doctor to have looked at you, and often a specialist. So that would be a concern I have. Unfortunately, you can't have them disqualified just because they're not doctors. But I think I would point out that here are the medical records from my doctor, who is a neurologist, who is board certified, who says this.
Right. And if you can, what we've had in the past is we've gotten our doctors to say, well, what's the difference in the training? You're board certified back doctor, what did you do that one of these people wouldn't, that might give you more leverage? And you'll find out a lot. It's like, hey, this is what I went to my 4 years of medical school, and then on top of that I did another 4 or 5 years of surgery, residential training. And so you want them to kind of state that, if they would, this is why I am more familiar with this, and this is why my opinion should carry more weight, versus somebody, as Carol said, is family practice, who sees a little bit of everything but doesn't really get into the depth that some of these claims require.
Our doctor, one of our experts, Dr. Miller, is very good at that. He says, I can't fault these people for their opinion because they haven't gotten the training. This is their training, and he sets it out, and this is my training. And it is just amazing, the difference. And to date, that has carried the day with the BVA. VA regional office, that's a toss-up.
Joshua Poole, I have a video appointment tomorrow for upping my disability, PTSD, and IBS. Any advice would be awesome. Thank you. Carol?
Once again, I wouldn't dress up. I'd be the way you are. I would treat them the way that you know well how you treated people when you wished you hadn't. I would make sure, if you have a problem with, look at the list of disabilities. Not only are you going to list all the ones in the criteria that you have, but you're going to talk about all of the things, nightmares, all of those things. And if you have suicidal ideation, what is suicidal ideation? It's when you really wonder whether it's worth being here. You wake up and think, do I want to live tomorrow? Maybe I'll just walk in front of a car. That's suicidal ideation. That's a 70% rating. IBS, Get the DBQ out. Look at the rating. You want to talk about, do you have constant diarrhea? Have you lost weight? Are you anemic? Look at what the ratings require, and then make sure you point out any of your problems that you have. And remember, if you haven't pointed out to your private doctor what these are, you need to start doing that as well. Because when it gets to the BVA, a lot of times they're going to read, somebody's actually going to read your medical records, and they're going to be looking to see what's in there.
Right. One thing I'd say about PTSD, if you are already at 30%, do not talk at all about sleep, flashbacks, night terrors, because the highest rating you can get for those is 30%. You want to look at what Carol was saying. Do you have suicidal ideation? Do you not like being around people? Do you hate authority? Can you just not stand being in crowds? Those are the kind of things you want to speak to. But knowledge is power. Get that DBQ for PTSD and look it over. Same thing with IBS. Look it over and say, I fit here. And once you say I fit here, make sure you're ready to tell the person tomorrow give examples of why exactly you fit there.
And Matt, while we're talking about this, I think as soon as you have the CNP exam, you should always write for a copy. Yeah. Always. You need to know what these people are saying, because sometimes I will see that the exam was really favorable, but that's not what the rating showed. Or the exam wasn't so favorable, but for some reason you got a better rating. You need to know what these people are saying. And likewise, you need to know what your private doctors or your VA doctors are saying. You should have a copy. I have lots of veterans that come in and say they talked to my doctor about this and this. You look at the notes, nothing there. So if you have doctors who are not adequately documenting your problems, you maybe need to go to another doctor, but you need to know those doctors are not going to help you when the VA looks to rate you, because nothing is in those files.
All right. Good question, Joshua, and good luck to you tomorrow. Please get back to us. Let us know how that goes.
Yeah.
LOMF always. Should a DBQ override the need for a CNP exam? Should. Yes, it should. Does it? No, not typically. They have, the VA is supposed to expedite claims that are what they call fully developed, meaning if you hand in a claim and you say, here's my diagnosis, here's what happened in service, here's the nexus, or this is my diagnosis, it's service connected, it should be higher, here's the DBQ, go ahead and rate me. We don't see that happen. What we see is the VA says, oh, look at this. This is a nice piece of evidence. Let's have our doctor comment on it. And so again, in that situation, even though you have a complete file, even though that's ready to rate right there under the law, you got to go to the CNP exam or they get a free pass on denying you. Cecil Dixon 19, I unexpectedly received a call from LHR telling me I might receive a call from CNP exam for GERD, but I didn't receive any call. So should I be expecting a rating? I would call VA and say, I haven't gotten a call on this. I mean, if you put in a claim for increase with them, I would say they said they were going to call. They never called back for the substantive discussion.
There may have been routine reviews too, Matt. They may have been routine review. So, right, call the VA and ask them why that happened.
Yeah. Okay, Rico Mai, good afternoon. Awaiting a medical opinion / clarification CNP for Pact Act Psoriasis, PSA, and hypertension. Exam request went out to LHI in February 22. Not scheduled for the opinion yet. I'd be complaining on that, Carol. I mean, they've held back some of these cases because they say that the effective date isn't there yet. I don't know, Carol. That's 13 months ago.
Yeah, I would definitely find out what's going on. They were only asking for an opinion, so they wouldn't have contacted you if they just want a medical opinion in most cases, but something should have happened.
Yeah, you should have seen movement. I think that's
over a year ago, right?
Yeah.
LHI, my favorite company, that doesn't exist anymore. It's now Optum. They changed their name.
But not the quality of care.
No.
Alan, how long after a CNP exam should you normally hear back? We discussed this earlier. I would like to say within 4 weeks. It could be several months if there's any back and forth between the examiner and the adjudicator. It's hard to put a pin in it.
Like Matt said, for some reason, before people had an exam, they made a decision, and now for some reason, I mean, I see examiners sending, I want a stronger medical opinion, or I want you to consider these facts. I see it all the time now. They're sending it out, So you may have 3 or 4 medical opinions for the same question in there, which continues to delay because each one is like 30 days.
Okay, JD, afternoon. Seeing VA for secondary stress due to service-connected ratings. VA notes that I have depression over it and I'm getting meds. Do I have to go to CNP or televisit?
I'm
Carol?
not quite sure. Secondary stress.
Must be in mental health. If they schedule you for an exam, you got to go. I mean, I hate to be the one beating that drum, but that's the law.
Yes, you have to go to the CNP. For some reason, there'll be televisits, and other reasons there won't. And I have clients who really can't leave their house, and they fight me about it. And then other people who could clearly get there, they set up a televisit. So I don't understand what their criteria is for that, Matt. Do you?
Flip of a coin? I don't know either. Yeah. Yolanda Frugid Adams. Sorry, Yolanda, I think I messed that up. Why would I be sent to a CNP exam for the same condition twice within 1 month? Carol, this is what you were just talking about.
Yeah. I don't know why, but we're seeing this. I don't know if the medical opinion they got from one doctor they don't like, or if that person didn't evaluate you in all the areas that they want that are crucial. I read these opinions and sometimes I don't see a real purpose for what they're doing, but they continue to do it. You know, before the VA did the exams, and I didn't see this, but now that these companies are doing it, I see it over and over and over again, and I don't know why. There's usually no reason other than sometimes it looks like the examiner wants to deny and they're trying to push the person who made the decision into agreeing with them. I do see that a lot.
Yeah. We are jaded. Full disclosure. I pitch East. 20% going for TDIU. I have one more CNP exam for depression. How long before a determination is made, and is it possible will they raise my disability instead? Hopefully they do raise your disability for the depression. Depression is a disability that I think is much more fairly rated in that you can get a proper rating, a 50%, 70% rating for your disabilities versus orthopedic issues like Carol was talking about the back. Trying to get to 40% is near impossible. Tinnitus caps out at 10%. Hearing loss, I can't say how many deaf clients we've had who have a 10% rating for hearing loss. So hopefully that depression gets you higher, and then you qualify for TDIU, the front door. 38 CFR 4.16a. There's the back door, meaning you don't have a 60% rating for one issue or 70% for another issue, and you have to go through the CNP services or the director's office in DC. That's a lot harder and a lot longer to get to.
And most of the time, the VA doesn't think to send you.
Yeah, it slips their mind. SDW, hello, Matt and Carol. It's my first live, and I thank you for all you do. I fall asleep listening to these sessions and have gained a lot of information and strategy. Thanks. Well, I don't know if it's a good thing that we bore you to sleep, but hopefully while you're asleep, you hear things that do help your case and get you going in the direction you need to. But thank you for the compliment. We appreciate that.
Thank you. Makes my day.
Tina Moore, is it standard for VA doctors don't give Nexus letters?
Yes.
I'm assuming you're saying treating doctors, and they're supposed to help their veterans, but they don't. We don't typically see that.
I know the VA issued an order that they will help you, and then whoever's in charge of the actual doctor say, no, you won't. And I wouldn't push them because you don't want them to make something they don't want to make.
Yeah, you don't want a bad opinion from them because that's
right. That's going to be stuck in your file.
Yeah. Vondi, tips for TBI C&P exam. Carol?
First of all, don't exaggerate. They have built into every one of these traumatic brain injuries exams questions that are trying to see if you're lying or trying to exaggerate your condition. And as soon as they see that, as soon as that's tripped, they're going to throw out anything that they find. So it's really important to do your best. But TBI is not just the brain, it's the whole body. So when you talk about TBI, you need to talk about the mental problems, memory, concentration, but the physical problems. How about vertigo problems? How about headaches, injury to any part of your body? You need to make sure The traumatic brain injury covers everything that it has caused you a problem with. And I would write down so that you have, when you get in front of someone, I know a lot of people think about the worst thing they can think of, but then they forget a lot of other things that are important too. So I would write down all of the problems that the TBI caused you. I would talk about the fact that you never had them before, but since you've had them, this is what you have. Unfortunately, TBI is a very difficult disability to adequately evaluate. And neurologists will do tests that take 3 and 4 hours. You're going to be sent to somebody that's going to ask you essentially 10 questions. Do you have a problem socializing? Do you have a problem finding your way around? And they're just doing a summary, and it's really not a good test, but it's the best you're going to get. So once again, get that DBQ out. And if I think it's always helpful to ask somebody, do I have a problem getting along with people? Because you may not know how you're acting. Do I get lost? You may be forgetting that you get lost. I'm serious about this. All of us try to forget the problems we have and go on with our lives, but that's not a good help for you when you want to present them to somebody else. So I would definitely ask somebody those questions, and if you can, take that person with you and have examples. I had a guy that said, when I leave my house, if I don't have my family or my dog with me, I can't find my way back home. I mean, those are examples that are really meaningful and really present how bad the problem is. That's the kind of thing you want to present for the TBI. When I stand up, I get really dizzy, and sometimes I fall. I've fallen and I've hurt my elbow. I've hit my head. Those are the kind of things that help them a lot more than saying I get dizzy.
Yeah. Well said. Margaret Rose, CNP examiner had recommended 100% P&T on 2 exams. Rater gives 60% and then 80%. Do they only listen to the examiner when it's a low rating? Currently 50% for PTSD, 20 for mood disorder, and 10% for tinnitus. Yeah, and one of the things that people don't realize all the time is the CNP examiner is offering up evidence. They are not making a decision on your claim. So even though you get a great CNP exam, you can get sabotaged like this. I mean, you have 2 exams showing how bad you were, and the rater just says, oh, well, you're not really that bad. That looks bogus to me and looks like grounds for appeal.
And look, it looks like they have, okay, remember, you only get paid for the higher rating of a mental problem. So it looks to me like they have tried to say your depression has nothing to do with PTSD. And so so you're getting paid for a 50% rating as opposed to a 20% rating, if that's the way you've got that. So if they had, otherwise, I would assume they would have PTSD with major depressive disorder. So that's a concern I have. Are they saying, look in the form that the examiner completed, and did they say you can separate the problems from PTSD from major depressive disorder, and the major depressive disorder is not related to the PTSD? If they did that, that's why they're breaking those out. And you need to make sure it's clear, I have depression because I have PTSD. It's not separate. So you really need to look at those reports.
Jacob C. I felt pain during my CNP exam and I left. My family was there. How do I appeal or address the situation to VA since my case got denied? You write a letter, your family, whoever, all the ones in your family write a letter, and you say, this hurt, whatever it was they were doing to you. And you could say, I would like a new CNP exam with a new examiner if the examiner themselves were hurting you. Or you could say, I showed up this day and I had a flare up and I just couldn't do it. But I would ask for a new CNP exam. They shouldn't have just denied you because you came and were injured. So that's what I would do.
And remember, when you ask for one, you need to say, I will attend. If you don't do that, then they may not accept that.
Kevin, can you take notes in a CNP exam to help you summarize all your issues that relates to your issues? Yeah,
Absolutely.
I would, especially if you have a memory problem.
Yeah, that shows it.
DC, what carries more weight, CNP exam, DBQ, or a Nexus? First of all, just with the terminology, it's important to understand a CNP exam is really for 2 things. It's one, to see is something service connected, is there a service connected disability? And part of that is determining if there's a nexus or a link between what happened in service and the diagnosis you have now. So a Nexus kind of folds into that, as it would with a private exam where you're asking your own doctor or hire a doctor, say, hey, is this PTSD related to the problem I had in service? And then they would give you a full diagnosis of PTSD. They'd say, well, this was a stressor in service, and yes, they are connected. That yes, we are connected is the Nexus. So when we're asking what carries more weight, it would really be what you're saying is an outside DBQ, either by your VA doctor or an outside doctor, or the CNP exam. Unfortunately, when we're in the regional office, I find that CNP exam almost always carries the day. They go with who they know, and they like how they write it up, and that's, that is what it is what I see. If you get to the board, if you have a doctor who gave a more well-reasoned statement and conclusion, I think you can win there.
And Matt, I think they're really talking about two different things. So when you go to a CNP exam, the doctor is supposed to complete a DBQ that gives you a diagnosis and talks about the problems that you have. And then there's usually a medical opinion that's separate that talks about the Nexus. So if the doctor may not be asked to do both, they may be asked, because you're already service connected, they may be asked just to do the DBQ.
Yeah.
If you're not service connected, then they'll probably be asked to do both. But what carries more weight? It's really all the same thing. It's an exam to see if you're entitled to service connection.
But you can have an outside doctor give a Nexus or fill out a DBQ.
But as Matt says, the regional office doesn't pay any attention to it most of the time.
Vanessa, combat husband, 9 IED explosions, 30% PTSD. TBI was secondary with 0% for migraines. Everyday headache now. Should we separate TBI from PTSD? Yes. That's what I mean. I got to imagine if he was blown up 9 times, there's more to the TBI than a 0%.
But remember, any mental problems, they're probably going to, the question is, can I separate the TBI mental problems from the PTSD? And if they can't, then you're going to get a rating that's joining them together. The things that don't go with PTSD from TBI are physical, the headaches, the vertigo, tinnitus, any of the things like that. So those should all be separated out. And you should definitely be getting a higher 10% for a headache at least every day. And then think about, does he have to lie down in a dark room? Is he able to concentrate? So what I have my veterans do is make a headache diary. They keep it for a month. And on each day they have a headache, they give me some information. How bad was the pain? Did you have to lie down? Was it interfering with concentration? I just get it for a month and then I turn it in. And then if I get a CNP exam that says he has one a month, and I've got a headache calendar that shows how many he has, or that he doesn't have to lie down, I've got some evidence that's saying, I don't know where they got these answers, but they're not the ones that the veterans gave. So document and then have somebody else document.
Juan, I'm rated with complex regional pain syndrome on my right upper arm. I have a labral tear and rotator cuff tear on my right shoulder. Is this something I can file a claim for? The question I'd have is, are they rating those already through the CRPS? Is that the symptoms they're using to rate you in the diagnostic code? If you have that tear, both the rotator cuff and the labral tear, do they cause loss of use, meaning you can't use your arm at all, but is there a loss of range of motion? If there's a range of motion issue, then yeah, I would file for those separately. But what I'm wondering is did they just rate you for those under the CRPS? And I don't know. But the question is, yes, you can file a claim and make them figure it out.
But if you do have the pain and you do have a limitation of motion, you should be rated for both of those if you have nerve pain. Yeah. So I would look at the exam they gave you, look at what they say. A lot of times, remember the piece of paper they never give you, it's the code sheet. You always need to write and ask for that, because that will show you what code they use to evaluate your rating. And if they didn't use the code they should have, then that's a good basis for appeal.
Okay, Jaram, during a BDD claim for secondaries, considering due to the BBB process, or only after 1 year service connected is up after ECS?
What's BDD?
It's when you're discharged to the discharge exam they do
Okay.
in service. So that's interesting. If you're still in service and you're claiming secondary problems, to me, they're directly related to service.
Right.
You know, if you've got sleep apnea that's secondary to PTSD, well, if you have sleep apnea in service, that's related to service. That happened while you were in service. It doesn't, in a way, it doesn't matter why it happened. It just matters that you already have that problem. So I wouldn't necessarily consider them secondaries. I would file for every single disability you have, even if
Yes.
it is secondary to something else. So don't wait. Jaime Gonzalez, are buddy letters enough to connect sleep apnea to service, or should I try to connect it to my anxiety, depression, PTSD? I would do both. The buddy statements can be really strong if you had people who were sleeping with you and they heard you snore, they heard you stop breathing. Those are very strong statements. It's hard to get it service connected secondary to PTSD or any mental health condition, but it can be done. I think the first line, the first option is probably better.
And those are claims that the regional office awards.
Yep. And we got LOMF always again. How do you find out if the VA is actually missing information or they're just denying your claim? The annihilator says that in your IMO diagnosed your depression something other than service connected, but says OSA. If there's more. Looks like we have an incomplete question
first of
there.
all, you want your whole claim file. You want everything, and you want the complete rating, which is the notice of action, the rating decision, and the code sheet. And then you want all of the medical. You want your whole claim file. You know, you can't really tell what they're doing until you read what they have.
And as far as the evidence they considered, you should look in the rating decision, and there's a specific section that says evidence, and they list everything in there they consider. So if you see something missing there, that's an automatic red flag, and you say, hey, look, I submitted this, or this in my VA medical records and it was not considered. Please re-adjudicate this.
So remember, there are 3 pieces of paper, and you only get 2. The first one is called notice of, it's the date, and says we have awarded you this, and usually it has the total percentages in the year, and then it will have the amount. And then the next document you get is called the rating sheet, and that says we are working on your claim that you filed on September of 2021, and we've made the following decisions. Okay, so that shows you, and that's the sheet that shows the evidence that they used, and you want to make sure you have that. And the sheet you don't get is the rating sheet at the bottom, the code sheet that shows the diagnosis and the rating code that they used to give that rating.
Yeah. Okay, we got time for a few more questions here, running short, but we want to take some more. Jacob, 2012, I filed for neck pain and numbness, was rated 10%, but never rated for radiculopathy. Refiled in October and was rated for 10% for neck, 0 for right, 0 for left radiculopathy. My records show medial and radial nerve damage with pain and weakness. Will the HLR rating Q for 2012 effective date? Also denied fibromyalgia. I requested as Gulf War. They said it's not presumptive under the Pact Act. All right, you got a lot going on here. If you had notations in your record of the radiculopathy back when they service connected your neck, then you have an angle to go back. I don't even consider that Q, Carol. I consider that an open claim that they just missed. It was, part and parcel of the claim you filed because it was in the evidence, and they didn't rate it, and it should have been rated. That's my thought on that. Carol, was that?
Yeah, but they're not going to do it on their own. You're going to have to.
Right.
I'm sure that if you win on the HLR, then you're just going to have to appeal for an earlier effective date and say why.
You don't want to use Q if you don't have to, because if you're showing as open claim, that means you get to submit new evidence. That means you can put, argue different law. But if you're arguing Q, it's the evidence in the record at the time, and the standard is clear and unmistakable error versus as likely as not if it's still an open claim. So you want to try the open claim angle. Hopefully the HLR will at least get you started down that by service connecting it and going from there. As far as denial of fibromyalgia, we see this all the time. If it's not fibromyalgia, you're in the Gulf and you have all the symptoms or almost all the symptoms of fibromyalgia, then it is Gulf War syndrome, and they should service connect it. And if they're denying you, you just keep appealing until we find somebody who can get it right.
So you want to put your medical records in, you want to point out what you've been diagnosed for, and then you want to just put the law under there and appeal.
Robert, will the CNP examiner contact your VA psychologist for information? That sounds like a great idea, Robert, but they're all about speed. They want to get you in, get you out, fill out the form, and get it done. So I have never seen that, and I would be shocked to see it, frankly. Eric, I've never seen any of these forms or rating sheets you're talking about. How do I request paperwork they work off of? Who do we talk to or contact to get these things? Carol?
You call the VA or you write a letter to the VA. First of all, you want your whole claim file. But then every time there's a rating, there are 3 documents. Tell them you want the notice of action, you want the rating decision, and then you want the code sheet. They will know what the code sheet is, and get them to send it to you. So you can either call the VA and see if they'll send it, but I have a lot of veterans that just write them a letter saying, please send me this. When you're asking just for a few things, they seem to get that out right away.
Yeah. Okay, let's take 2 more. Jaime Gonzalez again. Should I file all my claims at once? I have increased secondaries first times. All at once, always.
All at once.
All right, the last question is from CDW. How do I file for SMC for ED? Is there a form number? No form number. You just file it and say I have ED and say whatever it's related to, if it's a secondary from prostate or some other disability. And then you're right, they don't give you a rating for it. They give you SMCK compensation, which is, it's like an extra $150 they tack on a month.
So you file either the 526 if you've never filed for it before, or an 0995 if you have filed for it before.
Okay, folks. Well, we appreciate you coming in today and talking about CNP exams. Check out our newsletter. There's a ton more information. Got a couple videos. We actually have an article written by a CNP examiner in there to hopefully give you more information on what you need to do. Because remember, knowledge is key. Okay, that's your weapon. The more you know, the more likely you are to win your case. All right. So for Carol, we're signing off. We hope you have a great rest of your day, and go Alabama, I guess.
Yeah, we'll know next week.
Well,